would like to invite Dr. Raghavender Jia sir, former Joint Secretary and Senior Consultant at Department for Promotion of Industry and Internal Trade, Government of India, who possess distinguished career in public service. Dr. Raghavender sir has played a pivotal role in shaping India's intellectual property framework.
Sir has already introduced me.
Sure, sir.
Thank you.
Thank you, sir.
Vande Mataram and Justice Ravindra Bhatt sir and Ashok Kumar ji, Padmesh ji, and Dr. Anupam ji, and many faculty of this law school and dear students. It's always be happy to come back to my law school. I'm a student of LC1. I was just remembering how evening I used to catch my metro and complete my 75% attendance, religiously attending, unless my boss Amit Kare, now advisor to Modi sir, calls me back. You know, Kapil Sibal Mantri ji, a copyright amendment 2012 ke issue hai, discuss karne ko bulaya, everything, and catch metro again and go back. Those times no Ola, Uber. My batch was 2008 to 11. Then I fell in love during that time with the IP, and I wanted a specialization. I went to some other school to do my, satiate my hunger and also thirst. Everyone is talking about that AI is only a general purpose assisting tool. One should not get addicted to it, but use it just like you're using your smartphone or a laptop or computer or iPad and all that. So whether it is a ChatGPT or any AI model, a large language model, LLM model, we have examples of ChatGPT or Microsoft Copilot, Google Gemini and all that. So if you rely more on that, because what this technology is there, what I am telling you, like whenever law and technology is there, as students, law students, you try to understand the technology, then only you will be doing justice to your client, helping out to get justice. Now, tomorrow if you are a criminal lawyer, if you don't understand the forensic science, the basics, how you are going to argue and save your client. So similarly, when intellectual property rights, law and technology comes, the guy who is doing in the patent side, he should understand what is a biotechnology patent, a software patent, similarly AI patent. And so unless and until you go and deep, at least learn basics. So what you are filing, what specifications are written by the innovator, inventor, you don't understand. So basics are important. Of course, ChatGPT helps you to give some information, but don't rely on that. The young lawyers like you, 2 lawyers, they had a very short time in filing reply as affidavit in New York court. They took the assistance of ChatGPT, prepared a beautiful affidavit, and it gave 6 citations supporting their argument and their narration in that affidavit. And they were happy and filed that matter in the court. But judge is very intelligent, also learned. He went through that and said that these are all fake cases. Nowhere, no court has given such judgments. These guys were shocked. And court said, in the next hearing, I'm going to impose some sanction on you. Then he came back with, he's very saintly guy like our Justice Ravindra Bhatt, did not impose any heavy penalty on them. He said only the $5,000 punishment to you, because you have to be very careful using ChatGPT, because it also undergoes AI hallucinations. Hallucination. So you start imagining that here Anil Kapoor is sitting and talking about AI and personality right, or Jackie Shroff is sitting that his avatar has been created, and the avatar starts saying, hey, Bidu, and all that. He filed a case in Delhi High Court and won that. So the AI is doing these things a lot. Taylor Swift, she may be your favorite. using the metaverse, she created an avatar, and her avatar can give live performances if she is a busy person. And she can sign a contract with the producer. Wherever live concerts happen, she won't be coming. Avatar, Taylor Swift can do that. But Taylor Swift, physically, she gave using the metaverse, the virtual reality, augmented reality, or mixed reality, or the extended realities, the various spaces are there. Sitting in a drawing room, she gave a concert to millions of people all over the world. The beauty of the technology is, now if she is giving in the auditorium here, everyone can ask her to please sing my favorite song. The beauty of this artificial intelligence assisted metaverse, you can ask, hey Taylor, sing my song. This is my favorite. At least she will sing one mukda or one antara to satisfy her fans. So this kind of technology is coming. So these are all innovations. The moment innovations, they should be patentable. So many countries are coming out with their regulations of AI. AI about discrimination, equality, and privacy, and responsibility. That is very important. Even Niti Aayog in 2014 came out with a national strategy for artificial intelligence. The various ministries dealing with the various sectors should not work in silos, but should work collaboratively and coordinative manner. And then last year only, they came out with responsible AI for all, the first document. Why responsibility? The person using the AI, remember when in the E-Courts Phase 3 project, when as a joint secretary, we selected in coordination with, of course, Justice Chandrachud sir is chairman of the committee of the Supreme Court. Vidhi and Daksh, they did a study for the E-Courts, how, what should be the strategy of using these technologies for the courts, beginning from the Supreme Court to the 25 high courts and district courts. So there, the question of responsibility comes. Because AI does a lot of mistakes, not only the hallucination, imagining, and trying to, with my own experience, I ask questions about Indian patent law and Indian trademark law. It starts giving case laws and examples from the American and EU. So because you are a studious student, you read them, understand. Otherwise, you get into the same trouble. Those two young lawyers finally have to pay $5,000 each as a fine. So you have to be very careful. So technology is coming. So you should understand what technology is, that if you are a patent lawyer, whether it is a patentable subject matter or not. So you know that section 3K, which says that computer programs per se, algorithms, and business methods are not invention, not patentable. But following the concept which the Supreme Court of America introduced in Allies versus CLS Bank, even an examiner in the IP office follows the technical effect, the technical solution given by this technology in solving this problem, and also how the prior art, if you search in the prior art, what kind of inventive step it has introduced. This you see this explanation in the computer-related inventions guidelines of the IP office in 2013, which has been replaced in 2017. And in the recently, the Faridi Alani versus Union of India case, Justice Pratibha Singh gave a judgment saying that the 2013 guidelines were more stakeholder friendly. 2017 confusing because the definition of the technical effect, technical solution has been removed in the 2017. It is a case application, international application for the patent filed from the Tunisia. That's what being discussed. So how India has become then if it is not patentable, these problems are there. Top 10 AA granting countries in the world. Yesterday only there was a news I shared in Twitter and also my WhatsApp IP Darshan channel that India, 6G is coming now. In a 6G, India has already acquired 6th status in the IP office granting patents. The number of patent grant, the entire world in the 6G technology, India is the 6th position and slowly marching towards the 5th and 4th. So these technical developments are happening, and we follow the methodology which universally followed, granting the patents. But question comes whether AI itself, which autonomously inventing, can be recognized as an inventor. That argument has been defeated all over the world. And Thaler versus Vidal case, the Stephen Thaler, who invented a Davos AI machine, which in turn autonomously created food processing devices, for which a patent has been filed. Kathy Vidal, a good friend of mine, she is the USPTO head. Recently, she came with a delegation. She was asking me how India is dealing with these matters. We said, the way US is dealing, we are dealing. You have rejected, and the Stephen Thaler went to the Supreme Court and failed to get a favorable order because for creation, human ingenuity is needed for innovation or inventorship. The way Australian High Court, five-judge bench, Australian High Court has given a decision against Stephen Thaler's request, granting a patent for the doubles, because artificial intelligence machine cannot be an inventor unless and until a person working behind it. If you see the entire patent ecosystem or IP ecosystem, it is the personality based. There is a personality theory. The person has to be a natural person to be recognized as an inventor, or a design maker, or a copyright author. There is a personality based system in the intellectual property laws. And also, apart from the personality theory, there is an incentive theory. Why do you give it 20-year-long exclusive rights for when patent granted? Why do you give life of the author plus 60 years? Berne Convention says 50 years and 60 years. So there is no life for the machine. So you can't start introducing. But the people like me who belong to conservative romantic school, we don't accept giving any rights to a non-human machines. But there are revolutionaries, they say that no, autonomously it is creating, please give rights to a machine. But third school says that no, it should be recognized as a legalistic or a juristic aspects, and it should be given law. There is a case, Jeevan Publishing House versus Rupendra Kashyap. I think it's a Delhi High Court case, if I am correct, if not Supreme Court. In this clearly mentioned that CBSE itself does not draft the questions. It is they engage a teacher or a professor who draft the question. And the section 17 subsection of the Copyright Act says that the first owner of the copyright is the person whose expression, the author is also first owner. But 17B and C, when the contract basis or a commission basis is doing that, the ownership will go to the legal or a juristic person. So this is the law in India, and universally no one is granting that. Coming to the authorship also, there are many problems created by the artificial intelligence in the data mining. Again, I told you that try to understand the technologies, whether it is the LLM model, natural language processing, which Padmish was mentioning, the generative AI, which employs whether the machine learning, whether it is a supervised or unsupervised machine learning model when the data is a systematic, and then is a supervising learning happens when the data is unsystematic, not labeled. Or just now was this with Justice Bhatt, when the photo is taken, the document it is uploaded, how LLM model can read that? Only the neural network like computer vision can read that and extract the data. So data collection and the tokenization and categorization, various steps happen within the fraction of seconds. And the finally output comes out. Again, output, there is a big issue in the matter has not gone to our courts, but in US Supreme Court and the UK and EU, they have rejected recognizing AI models as an author. Recently, Jason Allen, who created using the Midjourney generative AI, beautiful photo. He says that my photo got an award in US competition that is being infringed because US Copyright Office refused to register it because it is not a human creativity. So recently we have given a reply to the Parliament how you are going to deal with this inventorship and authorship. So we said that present law, the general principles mentioned in the patent law and copyright law recognizes the AI creativity only for the natural persons, because copyright law section 2C6 clearly says the person behind the computer for the computer generated works, the AI generated works, it has to be the author who is the natural person. And the latest technology for which the Nobel Prize in Physics was awarded last week only, Geoffrey Hinton. Geoffrey Hinton got Nobel Prize in Physics last week. What is his invention? Invention is again AI and neural networks. He was trying to comment like Oppenheimer when he invented atom bomb. When atom bomb exploded, when he was reciting the Bhagavad Gita. And similar way, he is saying that the AI is going to, because when a strong AI is coming, it may create problems because it may start thinking autonomously like human. We have to be very careful, that's what he said. And that is a very important statement he has made while receiving the award. So we have to be very careful in that. But IP, I believe, keeps evolving, because my last statement before I rest my mouth, in fact, my speech, our friend Elon Musk made a statement a couple of months ago on his X account that digital God has taken birth and copyright law will die. I said no. What is he mentioning digital God? That is artificial general intelligence, the strong AI. That's what the Geoffrey Hinton has invented and got the Nobel Prize in Physics, the artificial neural networks. So this is going to come, they kill the copyright law. I replied in briefly in 140 characters saying that the printing machine came, copyright law took birth, and the phonograms and music, then technology came, from Berne Convention to Rome Convention came, and WIPO Internet treaties came to address the digital piracy. And now AI will also be handled by the copyright law, and that's what the law schools like Delhi Law School teach and groom the students to make the law stronger, and they take the copyright law to the next generation. Thank you. Jai Hind.